But since last night, my lord, he's suffering from high cold and fever, my lord, and also, my lord, cough, my lord. So he is paid for not today only, my lord. It may come next week, my lord.
इसमें तो दोनों में counter affidavit will be required.
Yes, my lord. If my lord go direct for filing counter affidavit, that will be.
Because 16 में appeal के बाद ये आए हैं और 17 में limitation का ground लिया.
Yes, my lord. Yes, my lord.
काउंटर मांग लेते हैं फिर इन लोग से.
Counter is required in both the matters.
हाँ, तो आप रुकिए दीपक सिन्हा जी, आपका
My lord.
अदर साइड को जरा बुला लीजिए तब उनके प्रेजेंस में.
My lord. My lord.
तो ये क्या होगा, एलपीए का जो आपका हियरिंग था एडमिशन?
He has instructed us to note down the argument by Mr. Garodia, my lord. We'll note the argument, my lord, Mr. Garodia, and if so required, Mr. Podar will give reply on the next week, my lord. Any day, my lord.
We were
Convenience of mine.
likely to conclude it today.
Yes.
Yes.
देख लीजिए जब कॉल होगा तो जैसा.
Fine.
और मिस्टर रहमान, आपका ये आइटम 4 सप्लीमेंट्री लिस्ट का जब एडमिशन कॉल होगा तब करेंगे.
Lordship, in serial number 14,
Yes.
we have already prayed for adjournment as advocate on record Miss Amrita Sinha has been tested positive.
उसमें लिखिए आइटम 14. The prayer for adjournment has been made on the ground that the counsel for the petitioner, Ms. Amrita Sinha, has turned COVID positive.
Yes, Lordship.
Is affected by COVID. So an email was also circulated. As such, let the matter hear after 2 weeks.
Much obliged, Lordship.
और एक आइटम 15 में भी adjournment था. 15 का कॉल करिए.
Item 15, Dr. P.T. number 1996 of 2020, Mr. Garodia for the petitioner, Mr. PSW for the
ये Mr. Sachin Kumar has prayed for an adjournment. Mr. Garodia.
Yes, my lord. He has said that one of his junior has tested positive and he is also having symptoms.
So, item 15 में लिखिए. The request for adjournment has been made by learned on behalf of learned to Mr. Sachin Kumar as his junior has tested. He is not feeling. He is indisposed, and juniors in his office have been affected by COVID. So, Sumit Garodia appearance कर दीजिएगा. So, let the matter be listed after 2 weeks. Then, Mr. Garodia.
Yes, any date is subject to your lordship's kind convenience, my lord.
27th January.
Obliged, my lord.
27th January.
इसका भी नोट कर लीजिए. आइटम 18 जो है.
आपका 18, 19 तो डिफरेंट है. नहीं, 18 is different, Mr. Garodia, but 19 to 22, these are GST matters. One of them is service tax issue.
My lord, I think all are GST matters subject, of course, my lord. I would have.
Item 21 is service tax April to June 2017, April 16 to June.
Okay, my lord. Then my numbering would have been wrong, my lord. But GST, my lord, now I have sent, my lord, to your lordships, my lord, I have annexed in this petition that the Honorable Supreme Court has granted stay. And my lord, as against the interim order, my lord, we had moved before the Supreme Court. My lord, I was appearing there, my lord. I was indicated by the court itself that it was only an interlocutory order and there is no res judicata. So now if the subsequent order is there of the Supreme Court, why don't you point it out before the High Court?
Okay.
And that is how, my lord, I had sent that order also to your lordships, my lord, yesterday on mail. I had taken liberty to withdraw the said SLP.
Okay. And that order, लिखित तो है, because आप फिर से भेज दीजिए. After a while, we will take it up.
I'll send it again, my lord, right away.
रखिए. Let us call the list. Correct?
Under 20 policy, under the heading for order to inside. Item number 1, WPS number 1, 307 of 2018, Mr. Sumit Kumar, for the petition.
May it please, Your Lordship. Actually, as per my Lord's last direction, Your Lordship, I have already removed almost all the defect, Your Lordship, except one.
No, as per the office note, there are defect number 1, 4, partly, 10, 15 and 18.
1, 4, 15, and Your Lordship, another one,
18.
18. I pray for some time, Your Lordship, so that I could remove all those defects. There are several defects.
That one can't help now, that is something.
Several defects. I am trying at my best to remove all those defects, Your Lordship.
Petitioner Mr. Sudhir Kumar undertakes to remove the remaining surviving defects as under within a period of 1 week.
No, Your Lordship, at least 2 weeks' time may kindly be granted.
Office to place the file.
Organize, Your Lordship.
Item 2, WPS number 4039 of 2019, Mr. Niranjan Kumar, former Commissioner, Mr. Gautam Gate.
The type copy of the defect may be ignored, my lord, and other defect will remove within a week.
No, please file the typed copy also. How can the court look into every page of the typed copy to see whether it is legible or not? If the stamp reporter says so, it is for the convenience of the court. Because you are getting time to remove the other defect relating to deficit, court fee, etc. So file the typed copy also.
The court fees have already been submitted.
ये तो 4 जनवरी 2022 का रिपोर्टिंग है जिसमें डेफिसिट कोर्ट फी 250 रुपए दिखा रहा है.
We'll check it, Lordship.
ऑथेंटिकेशन फी भी ₹10 बाकी है. Mr. Niranjan Kumar, learned counsel for the petitioner, undertakes to remove the remaining defects as under within a period of 1 week.
1 week, Lordship.
Office to place the file.
Item number 3, WPS number 1284 of 2020, Mr. Pramod Kumar, for the petitioner, Mr. Rajesh Nath, for the response.
Two weeks time. Who is appearing for petitioner? 2 weeks time.
Item number 4, WPS number 2032 of 2020.
Lordship, I am appearing on behalf of the petitioner, Your Lordship. 2 weeks' time may be granted, Your Lordship, to
2 weeks
remove
time.
the remaining defects.
Mr. Prashant Kumar. Shiva.
Yes, Your Lordship.
Office to place file.
Item 5, 17 of 2021, Mr. Amit Kumar, for the petitioner.
Lordship, in this case, we have removed some of the defects. 2 defects are remaining, Lordship. I was only praying for 1 week further time.
You have taken twice time earlier.
Lordship, actually, the type copy has been given, but the typist has not given till date, Lordship. I was only praying for further 1 week time, Lordship.
Malas, I only pray that let it be a preemptory order then, Malas.
During virtual hearing, we were not passing preemptory order. Na? You were inconvenienced. Councils wanted that no preemptory order. So what?
Only because Malas, twice time has been given. That's why Malas I was praying. I'll leave it to my Lord's.
I was only praying for 1 week, Lordship, for that time.
This time with a conditional cost if it is not removed.
Lordship, yes.
1 week more time as prayed for is allowed to learn counsel for the appellant, Mr. Amit Kumar, to remove the remaining defects as under, failing which the appellant shall have to pay cost of rupees 1,000 in Khalsa on the next day. For the respondent. नहीं, अभी रखो ना, जरूरत पड़ेगा।
Item 6, WPS number 353 of 2022, Mr. Mukesh Kumar Sinha, or the petitioner. Mr. Rajesh, Mr. Padmi Prasad, or the petitioner.
Your Lordship, praying for 3 weeks' time to remove the defects.
3 weeks time to Mr. Ankit Apurva. And counsel for petition.
Order. Item number 7, WPS number 319 of 2017, Mr. Akshay Kumar Naku.
My Lord.
Mr. Mukesh Kumar Dubey, for the.
Yes, Mr. Dubey.
My Lord, I am appearing in this matter for respondent. I have filed an affidavit as per the direction, but probably that are not on record. I have sent it through mail today.
Affidavit should be filed latest by 4th January.
हजूर 4th को डाल दिए थे, ड्रॉप बॉक्स में है वो, लगता है।
अब ये सारा डॉक्यूमेंट्स यू हैव एनक्लोज्ड टू योर एफिडेविट।
ITR डाल दिए हजूर 3 साल का और उनका इनकम स्टेटमेंट।
अब बच्चों का स्कूल का एडमिशन जो कराए उसका प्रूफ।
बच्चों का सर वो नया वाला तो उनके पास है नहीं, वो पुराना वाला 15-16 का हमको भेजे थे, तो 15-16 में तो इनका कोई डिस्प्यूट नहीं था, हम फाइल भी नहीं किए हैं, पर 15-16 का पेपर भेजे हमको।
आप ही न कहे कि इस साल आप एडमिशन का फीस वगैरह दिए हैं टाइम टू टाइम, तो उसका प्रूफ आपके पास नहीं है, आपके क्लाइंट के पास।
क्लाइंट के पास सर, हमारे पास तो डॉक्यूमेंट वो भेजे थे, उसमें वो तो नहीं था सर, पुराना फीस है।
But that was the direction.
कोर्ट में
दिस इज द
रिकॉर्ड किया हुआ है ना, तो देखिए आपके क्लाइंट इज प्लेइंग विद द कोर्ट।
हजूर अब क्लाइंट को अपीयर करने के लिए बोल रहे, इसको लास्ट में रख दिया जाए।
नहीं, एफिडेविट तो हम लोग के पास आया भी नहीं आया है ना।
नहीं,
तो फिर नेक्स्ट थर्सडे को रखते हैं, उस दिन
10 तारीख को हजूर रख दिया जाए ना। 10 को दूसरा केस भी लगा हुआ है यहाँ, फिजिकल अपीयरेंस वाला।
हाँ, तो लेकिन आपको एफिडेविट पे वो डॉक्यूमेंट्स एडमिशन रिलेटेड और फीस रिलेटेड लाना पड़ेगा कल तक, अदरवाइज स्मार्ट क्लाइंट को कैसे डील किया जाता है, वी नो दैट, है ना। लोग नेक्स्ट
फ्राइडे को रख दिया जाए,
थर्सडे फ्राइडे तो
थर्सडे को ही रख दिया जाए,
थर्सडे को रखिए। Then counsel for the respondent submits that an affidavit has been filed in the drop box on 4th January 2022 in compliance of the order dated 16 December 21. Stop. However, the same has not been placed on record. On being asked, then counsel for the respondent submits that ITR returns for last 3 years have been enclosed, but documents relating to have only been enclosed. Stop. In the previous date, the respondent was supposed to appear with the documents/receipts, etc., to show that he had been bearing the expenses for education of their children, as also undertaken by him on 19 February 2020 before this court. Stop. By the last order, he was also directed to indicate the nature of arrangements that he is going to undertake to ensure that the studies of their 3 children are not discontinued because of the persisting matrimonial dispute between the spouses. Stop. If the affidavit filed day before yesterday is not complete in all these respects, the respondent should ensure before the at least 2 days before the next date that supporting affidavit, the supplementary affidavit with supporting documents are also on record. Stop. Let the matter appear on next Thursday. The respondent should appear in person. If the in person in online mode through his counsel's office. तो कोई दिक्कत नहीं है ना नेक्स्ट थर्सडे को उनको आपके ऑफिस में बुलाने से?
हाँ ठीक है सर.
Where is the petitioner? Appellant? Is he लिंक भेजा हुआ है? Or the respondent, Mr. Srivastav?
Yes, Your Lordship, I am here for Your Lordship, my Lord. The matter is with respect to limitation.
And the main dispute is about vacating the premises of the Accountant General's.
Yes.
Nice.
But before Your Lordship, for condonation of delay, I have to, generally I will not oppose, but I have to point out certain thing which is very essential for the institution itself. Your Lordship, में other petitioner है नहीं appellant, इसीलिए otherwise I can point it out, my Lord.
नहीं, तो फिर we will give him one more indulgence.
Yes, I have no objection.
Appellant in person is not present today. He is taking the advice of a counsel and then appearing in person.
Yes, that is the reason. Para 8 is very important. Para 8 is contradictory to 6 and 7. Now, for condonation of delay, he is taking lame excuse for person in person. I think, my Lord, they are either malign the advocate and this conduct was previously in the writ application also. And on that ground, the writ was dismissed. That is one of the ground. But since he is not here, I should not say a lot of things.
Premises were vacated or not?
Yes, it has been vacated. Now he is contesting for refund of the money.
Refund of the money which has been paid.
Yes.
Appellant in person is not present today. So, respondent, state and accountant general are represented through their respective counsels. Mr. State की तरफ से कौन है?
Appearing for the respondent state, my lords. Respondent number 1.
AG1.
Yes, sir.
And Mr. Sudarshan Srivastav. In order to grant an indulgence, let the matter appear after 1 week. Suitable link we supply to the appellant in person and appellant to appear in person on the next date.
कोई डेट देंगे my lord कि ऐसे next date में?
ऐसा डेट भी दे देते हैं चलिए 18 जनवरी को कर दीजिए।
इन पर्सन है ना उनको डेट देना ठीक रहता
है। 18 जनवरी।
I'm obliged. Grateful, Your Lordship.
हाँ सर।
Supplementary वाला जो था।
Yes.
Item 4, WPS number 260, office level 20. Mr. Mohammed Jason, Brahma.
My lord, the petitioners have challenged, my lord, the order passed by the learned Central Administrative Tribunal, my lord, on the ground, my lord, has not been passed in accordance with the Annexure 4, which is the Railways Board Circular, my lord, which says that unless the conviction is set aside, and if the appeal is pending before this court, my lord, he cannot be reinstated, my lord. This is the only point, my lord, from the side of the railway, my lord.
The Supreme Court's order is there. Anyone appealing for the respondent?
Yes, my lord, I am appearing in this case, my lord.
Do you have any other judgment in support or only Lok Prahari?
My lord, the only that judgment, my lord, that is in my lord, so far as the issue involved in the case is.
इसको निकालिए जरा ये judgment लिखा हुआ है 2018
Two
Learned Counsel Petitioner Mr. Muhammad Jalsur Rahman and Learned Counsel Mr. Anil Kumar appearing for the respondent, applicant slash respondent. Stop. The only controversy raised in the present application is whether the only question is whether once the conviction has been stayed by the criminal appellate court, when the conviction of the applicant slash respondent has been stayed by the criminal appellate court, whether the learned tribunal, learned CAT, was right in setting aside the order of removal of the applicant from service dated 17th May 2018, imposed solely on the ground of his conviction. Para. Learned CAT, by the appeal order dated 22nd August 2019, passed in OA number so and so, took note of the orders of suspension of sentence dated 6th October 2017 within bracket annexure 2, and the stay of conviction
Twelve three 2018.
12/3/18.
of the impugned judgment of stay of the judgment of conviction by order dated 12th March 2018, annexure 3 within bracket, passed in criminal appeal DB number 753 of 2017, and also the decision of the apex court in the case of Lok Prahari versus the Election Commission of India and others, reported 2018 so and so.
AIR 2018 Supreme Court 4/7.
We have got the SCC also.
Okay.
Yes.
And appreciated the distinction between suspension of sentence and stay of conviction, and accordingly held that the penalty of removal from service on the applicant solely on the ground of his conviction by the criminal court deserves to be set aside. further directed payment of salary/subsistence allowance for the period of his termination/suspension.
Shall be decided.
Uh, it further directed the respondent authorities to
Take a decision.
take appropriate decision on the payment of salary/subsistence allowance for the period of his termination/suspension within a stipulated period. Stop. Learned counsel for the petitioner has referred to the letter dated Railway Board's letter number E within bracket D and A within bracket close 93 RG6-65 dated 6th June 1994.
This is RBE number 65 of 13, my lord, at the right top, my lord. 65 of 13, Railway Board Circular.
RG6.
RG6-65 है ना?
हाँ, RG6-65 है.
Dated 6 June 1994. And also the letter dated 8th July 2013 being RB number 65 of 2013, Annexure 4 series, to make his point that the railway ministry and the railway board has prescribed that mere filing of an appeal or stay of the execution of the sentence shall not take away the effect of conviction unless the appeal is allowed and the conviction is set aside by the appellate court. Stop. The circular, however, is silent as to the effect of stay of conviction. Stop. The learned tribunal took note of this distinction in the circular. And relied upon the decision of the apex court rendered in the case of Lok Prahari Supra, where the effect of stay of conviction by the appellate court under section 389 CRPC was an issue in the context of disqualification of members of the parliament/state legislature who were convicted for, who have faced conviction. The apex court held that once the conviction has been stayed during pendency of the appeal, the disqualification under section 8 of the Representation of the People's Act 1951, which operates as a consequence of the conviction, cannot take or remain in effect. The stay of the conviction would relieve the individual from suffering the consequence, such as the disqualification relatable to subsections 1, 2, and 3 of section 8. Stop. The principle of law enunciated on this issue does not permit of any departure in the present case, where the applicant had been removed only on the ground of his conviction, and that conviction had been stayed by the Criminal Appellate Court. In Criminal Appellate Court, by this court in Criminal Appeal number
753.
753 of 2017, by the next year 3, order dated 12th March 2018. Stop. The order of the Learned Tribunal tested on these principles cannot be faulted. So the question posed at the outset is answered in the affirmative. Stop. The writ petition is accordingly, being devoid of merit, is accordingly dismissed. Citation volume 18, SCC 114.
For everything, item number 9, WPS number 294 2017. Mr. Vijay Kumar.
May please, Lord. Lord, this is the order passed by, it's against the order passed by CAT at page 33, Lords. For a prayer, Lord, for commanding upon the respondents to grant the promotion to the petitioner on the post of Postmaster General with effect from 2007 and to the post of Chief Postmaster General with effect from 2012. Now, the only sole question which arises in this petition is whether the promotion of the petitioner can be denied on the ground of the adverse entries made against him, which was not even communicated to him. This is the sole question, my lord. The adverse entry has been made, my lord. The petitioner has been graded as good. The grading of good is, in fact, my lord, below benchmark grading, my lords. Petitioner is working in Indian Postal Service and he has got good grading. The good grading, the grade of good, my lords, is below benchmark, and that was required to be communicated to the petitioner within a reasonable period of time. Because I may indicate that a DP was.
Who appears Respondent Union of India, DOPT, who appears?
Lord, name of Lord.
That's the difficulty. We will take it up after the next case. You need to intimate Mr. Rajiv Sinha to be present.
Item 3, WPS number 3007 of 2019. Mr. Naveen Kumar for WPS Kumar, WPS office for the.
Well, item number 10, my lord, I am appearing on behalf of the petitioner, my lord.
Yes.
WP 3007, my lord. Well, before I place with the matter, my lord, during the pendency of the instant writ petition, my lord, the respondent has issued orders of attachment, my lord. But I intend to place them on record, my lord. I was seeking, my lord, lordship's leave, my lord, to take out a supplementary affidavit and lordship can hear out the entire matter, my lord.
Garnish notice has been issued. Counter has also not been filed.
My lord, there was a direction.
Although, my lord, I am only appearing for DGGI, one of the respondents who had issued the show cause notice. But when I went through the file, I saw that the order is an appealable order. The order challenge
But that I'll satisfy your lordship, my lord. With that aspect, my lord, I'll certainly satisfy your lordship, my lord. If I prima facie can show your lordship, my lord, there is a gross violation of the principles of natural justice, my lord. This honorable court has immense power, my lord, to entertain an application of this nature, my lord. I was only beseeching at this juncture, my lord, if lordship may grant me leave, I take out a small supplementary affidavit, bring the document on record, and lordship can hear out the matter in its entirety. And
So, Mr. Ratnesh, you had earlier been granted time on 9th January 20 to file counter. If you are,
My lord, I am not appearing for the Central Excise Department in this case, my lord.
whose name is appearing for that? Your name is not appearing. Yes, your name is.
My name is appearing for the respondent number 2 only. The contesting respondent is 1, 3, and 4. 3 and 4 basically.
Now, on the last occasion, the respondents were represented before your lordship, my lord.
Lordship, my senior, Mr. P.S. Pati, is representing GST, Your Lordship. His name is appearing in this matter.
So you were granted time earlier on 9th January 20. Union of India had taken time. Union of India has got not much to do with this. So we want to know from Mrs. Ranjana Mukherjee whether you are going to file a counter affidavit, whether you consider it necessary to file counter affidavit, or
No, Your Lordship, we have already sent the counter affidavit for signing, Your Lordship. It has not come yet. It is my senior is supposed to be appearing in this matter, but he is not joined right now.
it's almost 1 year since that order was passed, 9th January 2020. In fact, 2 years, 9th January 2020. So, Mr. Chatterjee, the counter is not on record. You are going to press the petition with submission that alternative remedy is not a bar in entertaining.
Yes, yes, that will be my specific case. I'll try to demonstrate, my lord, from the.
Let the counter affidavit then also come, and you also bring on record the letter document which you want to
Yes,
bring.
my lord. I'll do that. I'll do that. But in the meantime, my lord, I was only praying, my lord, no further coercive steps may be taken, my lord. Because, my lord, what they have done is pendency, because pendency of the appeal, my lord, that is what I intend to bring on record, my lord. Lordship fixes that a very short direction. I'll take a day's time, my lord. It's already ready. I've been assisted by Mr. Rahul Lamba. So it's ready with him. It can be filed tomorrow itself. Lordship can take it up any day convenient to your lordship. We are otherwise ready with the matter.
No, we would like to have the stand of the respondent also.
Yes, yes, very, very well, very well.
Mrs. Mukherjee, by what time will you be able to file? 1 week? Unmute yourself. Unmute. You are muted. Please unmute yourself.
I'm so sorry, Your Lordship. Your Lordship, 1 week's time, because we've already drafted and sent it for signing. It has not come yet.
He has an urgency. Petitioners' counsel is also saying that garnishing notice have been issued. So we can keep it after 1 week. Petitioner would
Yes,
file
Your Lordship.
documentary affidavit. You file your counter affidavit, and in that way, pleadings would be ready. We can keep it on 25th January.
25th, very well, very well.
Yes, Your Lordship.
Today is 6th. 25th January we can keep it out. 19th January.
As convenient to your lordship. I'll leave. My 25th is 20 lordship. I'll come back on 25th before your lordship.
25th January. Counter affidavit. This is Ranjana Mukherjee, counsel for the CGST submits that counter affidavit is ready and has been sent for vetting. It would be filed within a week. Stop. And counsel for the petitioner submits that he would be filing a supplementary affidavit to bring on record certain documents which have been issued during pendency of the writ petition in the nature of a coercive action. Stop. Mr. Ratnesh Kumar appears for TGCEI.
Now it is DGGI.
DGGI. Respondent number 2. Let his name appear in the cause list henceforth. Stop. As prayed for by learned counsel for the parties, matter be listed on 25th January 2022.
Copies of the counter affidavit may be served, my lord, in little advance to us, my lord.
Yes, yes, yes.
I was also praying, my lord, in the meantime, my lord, let the respondent not take further coercive steps in the matter, my lord. Since it's in session.
We have not even applied our mind. That document of garnishing notice is not there on record, so and that's power of alternative remedy. All that we will hear on the next day.
Very well, very well, very well. I'll come back, my lord. I'll try and satisfy your lordship on all these points, my lord.
Yes. And any decisions, etc., which you want to rely, please send it by the preceding Friday, that is 21st January.
Very well. I'll do that. I'll do that. I'll mail across to your lordship's officer, my lord.
If parties, if so advised, would submit their written notes and decisions on which they seek to rely latest by 21st January 2022 through the court master in hard copy also.
Very well. We'll do that. We'll do that, my lord. I'm extremely obliged, my lord.
Obliged, your lordship.
Obliged.
Item 9. Item 10 में कहाँ उनका नाम? अच्छा, sorry. Mr. Ratnesh Kumar का नाम.
My name was appearing for Central Excise, which now continues.
Yes.
Item 11. Article number 29 of 2021. Mr. Arun Kumar for the argument. Mr. Muhammad Imtiaz Khan.
Also, I am appearing in this case on behalf of the husband, OP number 2, my lord. Also, I have to bring some of the facts on record, my lord. And so, lord, seeking 3 weeks' time, my lord, to file counter. I mean, the one fact has come in para 10 of the application that the petitioner has not moved earlier before this honorable court. While, my lord, the reality is, fact is that he has earlier moved also, my lord, in first appeal number 79 of 2016, which was disposed of by the order of the honorable division bench on 10/1/2017.
This appeal arises out of the dismissal of the suit of the wife.
Yes, my lord.
Original suit 9 of 17. Which other appeal you are talking about?
There is earlier he has also moved before this honorable court, my lord.
No,
by filing
arising from some other suit or from the same suit?
No, arising from other suit, my lord.
So that's a different cause of action.
Different issue.
So we will admit it. Mediation has failed. We will admit and call for the lower court records. If you want to bring that judgment on record, it is open for you to do so.
Yes, Lord. Some of the documents, Lord, I am willing to, Lord, bring on record, Lord. There is some mediation paper, my Lord. The matter has been compromised between the parties, my Lord.
But
and the father of the OP number 2 has given rupees 3 lakhs, my Lord, some of the documents, my Lord, and seeking, my Lord, 3 weeks' time, my Lord.
You do
As for the report of Jhalsa, mediation has failed, perhaps.
Yes.
Mediation failed, my Lord.
Okay. Mediation has failed as per the report of learned mediator Jhalsa bearing letter number 2699 dated 6 December 2021. Despite best endeavors and efforts and endeavors of both the parties. Stop. Admit call for the lower court records in connection with so-and-so from the court of so-and-so. Stop. We will not say what you want to file. It is up to you to bring on record.
Yes.
My lord, obliged.
Item 12. Article number 42 of 2021, along with item number 30, Mr. Arun Kumar, Mr. Niranjan for the advice. And both for the response.
My lord, we have filed the Wakadama. Now,
Both parties have the
now the copy of memo of appeal may be exchanged so that we may come to know that,
What points they have raised?
Same impugned judgment.
Same impugned judgment.
Husband and wife.
No. Daughter-in-law and father-in-law.
Into daughter-in-law. Into daughter-in-law.
Guardian
Plus
and
of the into
Daughter-in-law and father-in-law.
yes.
3,000 per month to the daughter-in-law. This is also you want to resist. Ask them to mediate in Jalsa.
I mean, the copy of the memo of opinion may be exchanged, my lord.
That learned council should exchange, but in the meantime, let them join mediation at Jalsa.
Yes.
It's a dispute between my daughter-in-law and father-in-law. The daughter-in-law must have become destitute after the death of her husband.
Death of her husband.
Earlier, the mediation had taken place when she had filed the case under section 498A, and that was, and there was a one-time settlement also.
for the
Jalsa. Not
One-time
in
settlement
Jalsa.
also.
Let them come to Jalsa and see that the dispute can be settled.
new council lordship है धन्यवाद lordship.
नहीं
ये
धनबाद धनबाद में पहले हो चुका है, इसीलिए वहां इट विल नॉट बी फ्रूटफुल.
धनबाद में हुआ वहां वन टाइम सेटलमेंट हो भी गया.
तो डाउटर के
वो सारी बात मीडिएशन में मीडिएटर के सामने रखिएगा आपके क्लाइंट.
सेटलमेंट वन टाइम.
ठीक है, वन टाइम चलते हैं तो आप सेटल कर लीजिए मीडिएशन में.
मेमो ऑफ अपील का कॉपी दे दिया जाए, कभी जाने
हम ही दे देंगे, हम दे देंगे. आई शैल सप्लाई.
वो तो आप लोग एक्सचेंज कर लीजिए. तो 20 तारीख को बोलते हैं अपियर करने.
20 को 19 तो किया जाए. हाँ किया जाए, 20 को किया जाए.
या 21 को करते हैं. 21-22 लगातार 2 दिन कर लेंगे.
नहीं हमको एक्चुअली क्या है कि ही ओल्ड मैन system also, so I will out of session since 21st.
अच्छा.
21 से 27 तक के बीच में हम आउट ऑफ रांची है.
तो 20-21 तो आप है ना.
May I submit one thing?
Yes.
And due to present pandemic, I mean, some more time will it?
Yes.
Because he's an old man. So physical Jhalsa mein, whether they will be able to for through video VC or not, it is not possible.
फरवरी में रख दिया जाए. इतना दिन हुआ ही है.
ऑनलाइन तो हो ही रहा है झालसा में.
ऑनलाइन हो रहा है. ऑनलाइन whether he will be able to do, then it's okay.
ऑनलाइन कर लीजिएगा आपके क्लाइंट मिस्टर निरंजन सिंह.
हम आई मीन
अरे क्या है, चली जाइए, आपको फीस मिलेगा.
नहीं ऐसा नहीं है सर.
सुनिए दिल्ली से धनबाद के ऑफिस से ऑनलाइन ज्वाइन कर लेंगे.
नहीं हम ये बोल रहे हैं कि हम अभी तक का क्लाइंट को जानते भी नहीं है, मिले भी नहीं है. आई हैव ओनली सीन हिज डॉक्यूमेंट्स एंड आई हैव गॉन थ्रू द डॉक्यूमेंट्स ओनली.
नहीं ऑनलाइन तो हो रहा है, दैट इज ट्रू.
ऑनलाइन हो रहा है.
तो ऑनलाइन नहीं किया जाए.
ऑनलाइन कर लीजिए पहले डेट को, बाद में थोड़ा
इसको
कोविड कम होगा तो फिजिकल करिएगा.
इसको फरवरी के फर्स्ट वीक में रखा जाए, हो जाएगा उस समय तक. ये
I have no objection. Either physical or online.
Daughter-in-law has got a maintenance. Daughter-in-law has been awarded maintenance at the rate of 3,000 per month to be paid by the father-in-law by the impugned judgment.
The date of the order.
2021 passed in original suit number 242 of 2018 under section 19 of the Hindu Adoption and Maintenance Act. Both the both of them are in appeal. Stop. In such a matter, parties should take recourse to mediation. Stop. Because of the surge in COVID cases, mediation can be held at Jhalsa. And if the situation eases, parties may be asked to appear physically later on. As such, let the parties approach the London Member Secretaries Jhalsa on the following numbers on 20th January 2022. Stop. आप मिस्टर निरंजन सिंह, आपके क्लाइंट को डीएलएसए हजारीबाग से चाहिए ऑनलाइन का फैसिलिटी, तो आप बोलिए, ऑर्डर में लिखा दे रहे हैं।
डीएलएसए हजारीबाग कर दिया जाए, कहा था वैसा हम
In case the parties do not have proper digital facilities to join the mediation online, they may approach the concerned DLSA or Hazaribagh, as the case may be, for assistance. Stop. Such intimation, however, be given prior in point of time to the Member Secretary Jhalsa on the same phone number, so that adequate arrangements can be made at the DLSA Dhanbad and Hazaribagh on the date fixed. So, needless to say, parties should cooperate in the mediation proceedings and attend each of the sittings. If the situation eases, it should be open for the learned parties. It would be open for the learned mediator to require their physical presence for mediation at Jhalsa on subsequent dates, as for the convenience of the parties. So, if they are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 6 weeks from today. After 6 weeks from today, so matter be listed 6 weeks का जो week है उसमें, in the week of so and so, along with the report.
Any date?
You communicate to your clients. उनको ऑनलाइन चाहिए तो वो मेंबर सेक्रेटरी को पहले भी इन्फॉर्म कर देंगे, so that adequate
Oblige.
Item number 16, WPT number 225 of 2021, Mr. Manuda, for the petitioner. Mr. Amit Kumar, which appears for the respondent.
Yes, my lord.
Who is appearing for the history? And who is appearing for the state respondent?
Lordship, in item 18 and 19, I am appearing for CGST, Lordship.
Okay. So you file counter affidavit in both of them?
Lordship.
How much time?
Lordship, 3 weeks time.
इधर से मिस्टर दीपक कुमार सिन्हा for petitioner, दोनों में, other side Mr. Amit Kumar, दोनों में more or less एक ही order है. Then counsel for the respondent CGST, praise for is allowed 3 weeks time to file counter affidavit. 1 week time thereafter is allowed to the petitioner to file reply if so advised. Matter be listed after 4 weeks. Same order in item 17 also. Your name should appear in item 17, Mr. Amit Kumar.
Lordship, in that case, Mr. P.S. Pati is appearing, Lordship.
Okay. So,
This is item Lordship 1819 Lordship.
No, 16, 17.
I'm sorry Lordship. I'm appearing in 1819 Lordship. I'm sorry Lordship.
टीम में तो आपका नाम अपीयर कर रहा है, आप कर रहे हैं कि मिस्टर पति करेंगे?
मिस्टर पति कर रहे हैं 1670 दोनों।
तो उनको बता दीजिएगा कि ये ऑर्डर हुआ है।
जी जी।
Mrs. Ranga Mukherjee is on screen. Are you able to hear us? ज्वाइन करके लोग छोड़े रहते हैं।
हम बता दें।
ठीक है। Yes, yes.
Item ready. Double ID. 4609 of 2021, Mr. Sumit Gogia for the petitioner. Mr. Atul Kumar Yadav, Mr. Amit Kumar for the response.
May it please your lordships, my lord, the matter, my lord, subject to your lordship's pleasure, my lord.
Yes.
The matter, my lord, the petitioner has sought a declaration that the amount paid towards royalty is not leviable to, my lord, goods and service tax, my lord, under the GST Act 2017, my lord.
Yes.
My lord, the main contention of the petitioner and which is pending before the Honorable Apex Court, my lord, in this matter is that whether royalty is in the nature of tax or not. If admittedly, my lord, as on today, my lord, the judgment of India Cement holds field and it is held that royalty is in the nature of tax. And my lord, earlier occasion, your lordships, while dealing with the matter pertaining to service tax, had passed a detailed interim order in the case of Sunita Ganguly, where your lordships, taking into consideration the fact that the matter is pending to the Supreme Court and interim order has already been granted in the case of Udaipur Chamber of Commerce, your lordships were pleased to extend the stay with respect to service tax. But so far as GST, my lord, your lordships were of the opinion that no case is made out for GST, my lord. That order I have sent to your lordship. Subsequent to the order passed by your lordships, my lord, the order date of your lordships, my lord, in the earlier batch of matters were dated 2nd March 2021, my lord. I have sent that order, my lord.
Yes.
And in my memo of writ petition, my lord, if your lordships may see at page 41.
Yes.
Subsequently, my lord, even the matter.
निकाल दीजिए, सब एक ही है, 18 से लेकर के 22 तक सारा.
I think, my lord, all are GST only, my lord, subject to correction, my lord.
नहीं, you check up item 21. I personally saw it was a dispute for April 2016 to June 2017.
My lord, 21, my lord, the file, of course, my lord, there were two writ files for item number 21, my lord, but the same name. So I may be wrong also, my lord, because
Item 18 and 19 is with regard to service tax, Lordship, because two cases are filed, one with respect to service tax and one with respect to GST, Lordship.
I think, my lord, individual files of the Honorable Court would be the best answer because numbering generally, my lord, gets mixed up in the...
4609, that is 18, relates to GST for period July 17 to March 2020 on royalty and district mineral fund.
Yes, July 17 to March 2020, yes, my lord, this is GST.
This is GST issue, not service tax.
Yes.
इसके बाद का दीजिए.
Then 19, Bihar.
19 is
Bihar Battalion.
19 is again GST for July 2017 to March 2020. I am seeing from the synopsis, if it is in the main paragraph also, July 17 to March 20.
Yes,
minor amendment.
Then Bandhana Stoneworks.
Then comes item 20. Item 20 is also same.
Yes, my lord.
Which is also for GST.
One is Amba stone. That is
It is service tax.
Service tax.
Okay, my lord. Then that matter, I had wrong numbering, my lord. I had filed two writ petitions for
Wait.
April 16 to June 17.
ये अम्बा तो उनका कुछ prayer is slightly different. The period is not given. Let us take up the period.
In the impugned order, it is there.
No, then it is GST file only.
इसका पीरियड नहीं कहीं लिखा हुआ है इस पे.
हाँ मतलब पीरियड नहीं लिखा हुआ है इसमें क्योंकि मतलब we had filed this rate. If your lordships में see annexure 1.
अच्छा हाँ पैरा 2 में लिखा हुआ has not filed any writ application earlier. Our petitioner has also been issued notice with respect to service tax and has been advised to separately challenge the said notice pertaining to levy survey by a separate writ petition. The instant writ petition is only confined to prayer for declaration with respect to levy of GST for the period June 2017 to March 2020. तो इसका दूसरा रिट पिटीशन क्या टेकअप हो चुका है या अभी नहीं हुआ है?
नहीं हुआ है मलोड, अभी नहीं हुआ है वो रिट पिटीशन. दिस इज आल्सो जीएसटी देन मलोड.
The impugned notice at annexure 1 covers the GST period for which you are asking relief.
Yes, they give me details for GST also.
April 16 to June 17.
No, मतलब this
notice में लगाया हुआ.
नहीं ये नोटिस इसमें हमको नहीं आया मलोड. इट्स अ सिंपल डिक्लेरेशन. If your lordships may see my relief.
Okay.
I have not challenged any notice. I have sought for a declaration.
In other writ petitions, there is a notice.
Yes, in other writ petition, there is a notice. In this, there is a declaration.
Very well.
And last is Madan Khan.
इसमें भी वही है. GST July 17 to March 20.
Yes, Madan.
22 लगी ना serial 22.
And all the writ petitions are identical because
yes,
they
identical.
all stay on GST.
Yes, my lord.
तो फिर सबको क्लब करिए पहले 18 to 21.
22 sir.
करके लिखिए. In WP, all the writ petitions are being stacked together as they raise common issues relating to levy of goods and services tax under reverse charge mechanism on the payment of royalty and district mineral fund contribution paid by them to the state of Jharkhand in respect of their minor mineral lease. Stop. In WPT 4609 of 21, petitioner has, besides seeking a declaration that no GST is leviable on the amount of royalty and DMF contribution paid by him to the state of Jharkhand, also sought quashing of the notice bearing number 7241 dated 9th October 2020 issued by respondent number 2 to the extent that the respondent has held that there is liability towards payment of GST under reverse charge mechanism for the period July 2017 to March 2020 on the amount of royalty and district mineral fund contribution paid by the petitioner in respect of mining lease of stone boulders executed in his favor by the state of Jharkhand. Stop. In WPT number 4654 also, the same relief has been prayed for by the petitioner and the notice bearing number 1958 dated 2nd December 2020 issued by respondent number 2 within bracket annexure 1 for payment of GST under reverse charge mechanism for July 2017 to March 2020 on the amount of royalty and DMF contribution paid by the petitioner in respect to the state of Jharkhand in respect of the mining lease of stone boulders executed in his favor is also under challenge. Stop. In WPT number 4678, petitioner, who is also a lessee of minor mineral of stone boulders executed by the state of Jharkhand in his favor, has made similar prayer. The notice, impugned notice, is dated, bearing number 222 is dated 24th November 2020, Annexure 1, issued by respondent number 1, to the same effect. Stop. In WPT 4684 of 21, the appellant, the petitioner, has sought a declaration in similar manner that no GST is leviable on the amount of royalty and district mineral fund contribution paid by him to the state of Jharkhand against the mining lease of stone executed in his favor by the state of Jharkhand. Stop. However, no such notice has been issued in his case till date. Stop. In WPT 4864, petitioner is also a lessee of minor mineral stone boulders executed in his favor by the state of Jharkhand and has prayed for similar reliefs as in the other writ petitions. Besides challenging the notice bearing number 187 dated 21st November 2020, Annexure 3, issued by respondent number 2, seeking to levy, holding that the petitioner is liable to make payment of GST under reverse charge mechanism for the period July 2017 to March 2020 on the amount of royalty and district mineral fund contribution paid by him to the state of Jharkhand. Stop. Then counsel for the petitioners has referred to the order passed by this court in a batch of writ petitions led by WPT number 3878 of 2020, so and so, dated, order dated 2nd March 2021. Stop. This court, upon consideration of the pleadings on record and rival submission of the parties, had stayed the levy of service tax, the recovery of service tax for grant of mining lease / royalty of the petitioners. Stop. The interim order dated, operative portion of the interim order dated so and so, 2nd March 21 is quoted here under. ये paragraph 14, 15 को इसमें quote कर दीजिएगा. Stop. Learned counsel for the, it is submitted by learned counsel for the petitioner that this court had at the relevant point of, had however refused to stay the levy of to grant interim protection so far as levy of CGST and or JGST is concerned. Stop. It is submitted that where have you sent that order of withdrawal of your petition?
Malod, I sent it again, Malod. Yesterday also sent, right now also I sent, Malod, 1-page order, Baba project.
Achha, ye, haan, it is there. Then counsel for the petitioner submits that the Baba was one of the, no? Baba project.
Yes, Baba project was one of them, yes.
WPT number 206 of 21.
Baba project was WPT 1815.
185.
Yes.
Learned counsel for the petitioner submits that against the petitioners in the petitioners therein had approached the Honorable Supreme Court of India uh, against refusal of interim protection so far as the levy of GST is concerned on the payment of royalty, GST on the payment of royalty and district mineral district mineral fund contribution is concerned. Stop. Then counsel for the petitioner further submits that those writ petitions have been permitted to be withdrawn. Those special writ petitions have been permitted to be withdrawn by order dated 3rd January 2022, passed by the Honorable Court in civil special leave to appeal civil numbers 19196-19200 of 2021. As the petitioners propose to avail the remedy available to them under law, it is further submitted that the same issue had cropped up before the apex court. In the case, the same issue of levy of GST on royalty and district mineral fund contribution had cropped up. In writ petition civil number 1076 of 21, in the case of Messrs. Lakhvinder Singh versus Union of India, stop. The apex court has, by order dated 4th October 2021, within bracket annexure 3, stayed the payment of GST for grant of mining lease/royalty by the petitioner till further orders. Stop. Then counsel for the petitioner submits that in view of the interim order dated 4th October 21 passed by the apex court in the writ petition civil number 1076 of 21, the petitioners covered under the order dated interim order dated the petitioners such as Baba Projects Private Limited, etc., and others, within bracket WPT 185 of 21 and other analogous writ petitions have withdrawn the special leave petition to seek remedy before this court. Stop. It is submitted that in such circumstances, this court may be pleased to allow interim protection from recovery of GST on royalty and district mineral fund contribution paid by the petitioner. Stop. Whether we can grant the same relief, same sentence?
Yes. Supreme Court.
Learned counsel for the respondents submit that earlier this court had been pleased to grant stay of recovery of service tax for grant of mining lease/royalty from the petitioners covered under the interim order dated 2nd March 21, passed in a batch of cases led by WPT 3878 of 2020, though interim protection so far as levy of CGST and or JGST was refused. So, the counsel for the respondents, however, do not dispute that the apex court has since then been pleased to grant stay of payment of GST on grant of mining lease/royalty in the case of a similarly situated person.
Lordship, this thing may kindly not be, because we have just received this copy, Lordship, and we have to verify this.
No, what sentence do you don't want to be added?
That our objection is regarding, we have no objection regarding this this order of the Honorable Supreme Court.
No, we are not saying objection. We are saying no dispute. Is not able to dispute that the apex court has granted interim order.
That is the judgment.
Yes, that is judgment. But since
he is not in a position to dispute that the apex court, in the case of Mrs. Lagvinder Singh, has stayed the payment of GST for grant of mining lease as royalty. नहीं लिखिएगा. So, on consideration of the materials on record as placed by the parties, and in view of the interim protection granted by the apex court in writ petition civil number 1076 of 2021, in the case of Messrs. Lakhvinder Singh Supra, and that petitioners herein, lessees of minor mineral, also raise similar issue of levy of GST on royalty and district mineral fund contribution upon them, we deem it proper to grant similar relief to the petitioners herein. Accordingly, it is ordered, and accordingly, until further orders, payment of GST for grant of mining lease/royalty by the petitioners shall remain stayed. Let these petitions be tagged with WPT number 3878 of 2020, where similar issues are involved. Then it comes for the respondent, CGST and State of Jharkhand. कौन appear कर रहे हैं? Give your appearance slip.
Yes, Lord.
Are allowed 3 weeks time to file counter affidavit in the matter. 1 week thereafter is allowed to the petitioners to file reply if so advised. The matter will be listed thereafter along with WPT number 3878 of 2020.
Lordship, may I mention, Your Lordship, I was to appear in serial number 9, Your Lordship. I was in another court on legs, therefore I could not appear.
You pass over.
On behalf of respondents.
कब कर रहे हैं वो आपका?
Lordship, रिक्वेस्ट फाइल मेरे पास नहीं है, जूनियर के पास फाइल है, वो बीमार है, वो आ नहीं सका, इसलिए इसको नेक्स्ट वीक कर दिया जाए.
अच्छा, मिस्टर अभिषेक कुमार आप ही ना हैं आइटम में?
Lords, I'm appearing on behalf of the petitioner.
मिसेस आपको?
देवानंद कुमार के पास फाइल है, वो बीमार है, वो आ नहीं सके, हमको फाइल नहीं है, इस वजह से हम अपियर नहीं हो पा रहे हैं. नेक्स्ट वीक के लिए कर दिया जाए.
तो आपका नाम अपियर होगा कि वही देवानंद कुमार अपियर?
देवानंद का ही अपियर होगा.
उनको फिर कम्युनिकेट कर देना चाहिए था ना, हम लोग अपना ब्रीफ पढ़ के तैयार रहते हैं.
सर वो हमको इन्फॉर्म नहीं कर पाए थे, इसी वजह से हम कम्युनिकेट नहीं किए.
Passed over for the day on the request of learned counsel Mrs. Niva Bakshi for the petitioner Mr. Abhishek Kumar.
Obliged.
Obliged.
My lord, serial number 24, my lord. I am a.
हाँ क्या है 24 तो हियरिंग का है.
Today is not going to.
नहीं ऐसा कोई बात तो नहीं है, ये एडमिशन सप्लीमेंट्री लिस्ट का है. इसको जरा कॉल कर लीजिए, देखते हैं पहले देखना. सेकंड हाफ के लिए हम लोग अंडरस्टैंडिंग था.
Now the supplementary list for admission, item number 1 is bill number 85 of 2020 along with item number 2 and 3. Because we go to the
जरा ठीक करके दीजिए तो थोड़ा.
हम भी लगाते
और छोटा रखा रहता थोड़ा.
ये ना आदत को कर लेना. आदत.
Yes, this LPA councils are there.
Yes, madam.
Who is going to lead the state's argument? Mr. Piyush Chitresh. You see, Mr. Deepak Sinha, most likely will be concluded today from.
Yes, madam. We have concluded our argument.
State. So, and we might also deliver our judgment today.
My lord. My lord.
Please ask for time then after the arguments are concluded for any rejoinder. Whatever reply you have to give, you can give. You have prepared the written notes so nicely.
Yes, we have already submitted, my lord.
हाँ. तो ये हियरिंग मैटर में कौन लोग रेडी हैं? 23, 24, 25 में?
Your Lordship, serial number 24, Your Lordship. I am appearing on behalf of the petitioner, my lord. I have just received the wakalatnama, but I have already sent through it mail, and I have wakalatnama right from here, my lord. I have just received 2 days ago, my lord. So I could not find.
टाइम चाहिए ना?
हाँ टाइम.
हाँ टाइम दे दिया जाए तो अच्छा रहेगा, my lord.
24 में लिखिए मिस्टर मोहम्मद अंसिरुज़्ज़मा खान appears for the petitioners.
Yes,
the erstwhile counsel, Mr. Mohammed A. Khan, M.A. Khan, has unfortunately passed away during the COVID. The submission wakalatnama has been received and you will be filing it today.
No, my lord, I have already sent through the mail, my lord, but I will file it within 1 week, my lord, either 2 days or 3 days, my lord. I have already sent it through mail, my lord.
नहीं तो मेल वाला फाइलिंग माना जाएगा. आप ओरिजिनल ड्रॉप बॉक्स में फाइल कर दीजिए आजकल में.
Okay, my lord.
Should be filing the wakalatnama by tomorrow. Stop. On receipt of the wakalatnama, let the name of Mr. Muhammad Ansuruzzama Khan appear in the cause list. Mr. Khan.
My appearance.
Item number 23, I will appear.
Let me dictate the order, na. बीच में क्यों? मिस्टर विनोद सिंह, आपका भी लिखा नहीं जा रहा है अपीयरेंस. Mr. Khan prays for time to come prepared. Mr. Vinod Singh appears for the respondents. So, as prayed for, let the matter be listed after 1 week.
After 10th कर दीजिए my lord.
After?
After 10th January my lord. 2 weeks
तो
कर
आफ्टर 1 वीक तो इसका मतलब 17 जनवरी की लिस्ट में मैंने वीक में आएगा.
Yes.
Obliged my lord.
Lordships, may I mention serial number 23, Lords?
हाँ, 23.
On the side of respondent, Lords. Lords, yesterday I was not having the file, Lords. Today morning I have been given the file by the postal department. So, Lords, I have not been able to go through it entirely. Understood the issue, but Lords, I need to peruse the entire documents. Time.
And who is for petitioner in this?
S.K. Sharma, Lords, I have told
Yes,
him.
I'm the petitioner. I will ask.
Mr. Raj Bihari Singh Prasad. तो ठीक है, ये पास्ट ओवर फॉर द डे.
Yes, Lords.
पास्ट ओवर फॉर द डे.
Obliged.
25 में कोई है क्या?
Item 25 is number 4356 of 2016. Mr. Ashish Mohan for the petitioner. Mr. Guri Pandey for the.
Yes, Milords.
कौन है पिटिशनर की तरफ से और रेस्पोंडेंट की तरफ से?
I am for the respondent number 5, Milord.
अच्छा. और who is for petitioner?
Milords, I am appearing on behalf of Mr. Atanu Banerjee, Milords. He is on election on another court, Milords.
So you are ready? When the case is called out, you both of you will be ready? हाँ ना, कुछ बोलिए.
Yes, Milords. Milords.
ठीक है. फिर after we finish off these 3 LPAs from supplementary list, then we will get back to your case.
Okay, Milords. Milords. Alright, Milords.
पूजा हो रहा है.
Yes, Mr. Garodia, then you start. The State's Council is not ready for it.
Piyush Chitresh, my lord. He's probably joining, but I am starting, my lord.
Order to Yes.
Lord, the present batch of 2 appeals also arises out of a common impugned judgment passed by the Honorable Single Judge. And, my lord, in respect of the matters which had been labelled as W1 by the Honorable Single Judge, my lord, in the batch of matters which was decided by the Honorable Single Judge. And, my lord, my contention is that the issue involved in the present batch of appeal is squarely covered by a decision of the coordinate bench of this Honorable Court, my lord, passed in LPA number 112, 113, 119 and analogous cases dated 7th October 2021.
Yes.
Now, my lord, before coming to the order passed by the coordinate bench of this Honorable Court, my lord, may I just show to your lordships, my lord, the finding given in the impugned order by the Honorable Single Judge so far as the petitioner is concerned, my lord. My lord, the appellant respondent is concerned.
Which paragraph, which page?
Yes, my lord, just a moment, my lord. My lord, impugned judgment and order in the compilation given by Mr. Podar, my lord, is at page 299. Yes. And, my lord, I would like to refer only one paragraph because internal paragraph 32 of that judgment, my lord, of the learned single judge. Yes, which is at page 326, my lord.
Yes.
So far as the work W2 is concerned, it appears from the bank guarantee submitted by Messrs. NG Projects Limited that it deviated from the format of the bank guarantee by changing the condition of the bank guarantee mentioning banker's sole discretion, and the said deviation has been ignored by the state respondent.
Yes.
So this is a specific finding, my lord, which has been given with respect to the bank guarantee deviation of the respondent appellant before your lordships, my lord, private respondent appellant.
Yes.
And my lord, thereafter, my lord, the honorable single judge, my lord, had relied upon the principles of participation as enunciated, my lord, in Ramanand Dayaram Shetty. And then, my lord, the honorable single judge has held in para 35, my lord, only in the same page, my lord.
Yes.
I am of the considered view that the decision-making process of the state respondent, while rejecting the technical bid of P1 and by accepting the technical bids of private respondents as well as other bidders, suffers from arbitrariness and unreasonableness, more so when there were infirmities in the bid documents of all the bidders. The respondents appears to have adopted pick and choose method, which is not permissible in the eye of law, so as to satisfy the requirement of Article 14 of the Constitution of India. So, my lord, I stop here, my lord, with respect to the finding given by the learned single judge, my lord. I am not elaborating it, my lord, because this matter Mr. Pudar had held in detail, my lord. Now, my lord, it's an admitted fact, my lord, the case of the state also in the present matter, my lord, before the honorable single judge was that the bank guarantee was sacrosanct and any deviation from the bank guarantee could not have been condoned. And this is the case which the state has set up before the honorable single judge, my lord. Just one paragraph of the counter affidavit of the state government, which was filed before the honorable single judge in this present matter, my lord. If your lordships may come to page 40 of the compilation of given by Mr. Pudar, my lord, the counter affidavit on behalf of respondent state, and relevant is at page 46, para 14.
Page 46.
Yes, page 46, para 14.
Okay. And this has been quoted in our previous judgment.
Yes, exactly, my lord. So only to that extent I just wanted to show that even in the present writ petition, the stand of the state was not nothing new, my lord. The state had clearly and unambiguously stated that the bank guarantee conditions were strictly to be adhered with, and since, my lord, the writ petitioner had not adhered to the said condition, so its technical bid was rejected.
Yes.
So now, my lord, the stand which the state had taken before the honorable single judge in the counter affidavit was absolutely clear. And when it was noticed by the honorable single judge that if you are maintaining this stand that the bank guarantee was strictly to be complied with, then you could not have simultaneously deviated or permitted the bank guarantee submitted by the successful bidders, which were with deviations and material deviations, which I had demonstrated before the honorable single judge, my lord. And that paragraph I have shown, my lord, admitted paragraph is para 32, which I just read to your lordships, my lord. And my lord, the appellant, my lord, in the entire argument, advance has not even endeavored to say that the bank guarantee was not a deviation. And on the contrary, it is admitted that the bank guarantee was a deviation. All the endeavor was that the deviation which was there in his bank guarantee was a common deviation, whereas the deviation made in my bank guarantee was not a common deviation, and so it was not condoned, whereas their deviations were condoned and held to be substantially responsive. But this is not borne out of the record, the tender committee meeting proceedings which he has referred, because the argument advanced was, well, that the summary of the order was under challenge, and he had placed the tender committee minutes of the meeting. Well, that does not record any recording or finding that the bank guarantee of the private respondent appellant was in deviation, but it was condoned for all, so it was condoned for him. And this is precisely what the honorable single judge has held, my lord. If your lordship only, my lord, this is the last document, and then I'll straight away come to the impugned judgment, my lord. My friend has referred to the decision of the tender committee, my lord. I'll just show that, my lord. Page 342, if your lordships may see for a moment. It's in their second compilation number 2, my lord. Now, my lord, I am not reading it all for your lordships, my lord. All that I want to show is, my lord, 3 bidders' bank guarantees were rejected on the ground that it was not in the format. So, if your lordships may see page 343 for a moment, my lord.
Yes.
It is serial number 3, AK Construction Company, Varanasi, UP.
Yes.
I'll just read, my lord, very shortly. IFB की कंडिका 3 द्वारा बिड सिक्योरिटी कार्यपालक अभियंता पथ निर्माण विभाग पथ प्रमंडल गढ़वा के पक्ष में वांछनीय होना निर्धारित है, जबकि निवाधिकार द्वारा मुख्य अभियंता के पक्ष में बिड सिक्योरिटी समर्पित किया गया है। ये निर्धारित प्रावधानों का वायोलेशन है। ज्ञातव्य हो कि मुख्य अभियंता के नाम से कोई बैंक खाता संचालित नहीं है, अतएव संलग्न बिड सिक्योरिटी नल एंड वॉइड है। ऐसी निविदा जिसमें स्वीकार योग्य बिड सिक्योरिटी नहीं संलग्न हो उसे एसबीडी की क्लॉज 16.3 द्वारा नॉन रिस्पॉन्सिव घोषित करने का प्रावधान है। सो इट वाज डिक्लेयर्ड एज नॉन रिस्पॉन्सिव ऑन ग्राउंड ऑफ 16.3. देन my lord, serial number 7, Rajaram Construction.
Yes.
In that, my lord, clause 2 of that, serial number 7, clause 2, ये निविदा ई टेंडरिंग सेकेंड कॉल डेटेड 20/8/2019 द्वारा आमंत्रित है तथा निविदा की अवधि 22/8 से 4/9 तक निर्धारित थी, जिसका टेक्निकल बिड का ओपनिंग दिनांक 6/7 को किया गया था, जबकि बिड सिक्योरिटी संबंधित बैंक इंस्ट्रक्शन बिड डेटेड 18/6 से संबंधित अथवा हेतु निर्गत है। संप्रयुक्त बिड सिक्योरिटी अयोग्य एवं अमान्य है। ऐसी निविदा जिसमें स्वीकार योग्य बिड सिक्योरिटी नहीं संलग्न हो उसे एसबीडी की क्लॉज 16.3 द्वारा नॉन रिस्पॉन्सिव घोषित करने का प्रावधान है। एंड my lord, of course, in my case also at serial number 9, sorry, my lord, mine is serial number 8, my lord, I am not reading it. Was rejected, it was extensively placed. And page 345 is the discussion with respect to the private respondent. शेष 2 निवेदकार अथा एनजी प्रोजेक्ट हिम्मतनगर गुजरात एवं एमजी कंस्ट्रक्शन पंचकुला हरियाणा की निविदा substantially responsive है. So my lord, there is no discussion whatsoever with respect to alleged condonation of the deviation by the private respondents in their bank guarantee, and this is exactly what is the principles of participation, my lord, that if you set a standard, you have to rigorously follow the set standard, and if you deviate for one, then you deviate for all and provide reason for deviating. I don't say that the state government had no power to deviate. They could have done so, but you could have it should have been uniformly applied for all, and then you could have said that applying that uniform principle also, my bank guarantee could not have been accepted for the reasons stated in the order of the tender committee. That is not the case, my lord. And then, my lord, straight away, my lord, I am saying, as already submitted, that the issue is already covered by a decision of this coordinate bench of this honorable court. My lord, may I refer that judgment only a few paragraphs? Of course, your lordships have, your lordships were the author of the judgment, my lord, but subject to your lordship's kind pleasure, my lord.
Yes.
Para 23, my lord. At page, my lord, I would refer page 20, my lord. Para 23, it starts from page 19 of the Honorable Division Bench judgment. But from page
23?
No, page 20, my lord, 20.
20. Yes.
I am referring, my lord, this notwithstanding clause, my lord, from the top, my lord, 7 lines from the top, my lord, page 20. This notwithstanding clause relating to validity period of bid security is not in conformity with the format prescribed in the bid document, whereunder the employer has reserved his right to get the bank guarantee extended, and notice for such extension to the bank guarantee have been waived. It appears that the bank guarantee submitted by other successful bidders, Agarwal Global Infratech, appellant herein also suffered from the same discrepancy. Relevant part of the bank guarantee submitted by Agarwal is quoted herein under. My lord, I am skipping that. Then para 24 is very important, my lord. Your lordships in that case also had considered the bank guarantee of the private respondent NG project, which also is the private respondent herein before your lordships, my lord, the appellant. Para 24. Though other successful bidders were not impleaded as party respondent in the writ petition, but it was brought to the court's notice on behalf of P1 that the bank guarantee submitted by NG project also suffered from the same infirmity. It appears that the technical bid of other bidders who had presented the bank guarantee in the name of executive engineer, Road Construction Department, Road Division Garhwa, instead of executive engineer, Road Division Garhwa, was also accepted, though there were deviations in terms of the SBD and its addendum quoted above. It is evident from the aforesaid discussion that the bank guarantee submitted by the writ petitioner was not in proper prescribed format and not in conformity with clause 7 of the NIT read together with clause 16 of the SBD and addendum to clause 16.1. However, at the same time, the bank guarantee submitted by the applicant Mrs. Agarwal Global was also not in conformity with the prescribed format as regards the extension of validity period at the discretion of the employer and the waiver of the right to notice to the bank by the employer in view of the notwithstanding clause introduced in the bank guarantee. It was the specific case of the state respondent in para 14 of its counter affidavit that the bank guarantee had to be as per the prescribed format. There has been deviation in the name of the addresses in the bank guarantee submitted by other bidders as taken note of by the learned single judge. As such, in evaluation of the technical bid as bids as respect the bid security under clause 7, read with clause 16.1 and its addendum thereto, the tender evaluation committee did not appear to adopt uniform yardstick. This is exactly, my lord, I am submitting that this is the finding, this is the exactly similar facts which are involved in the present matter also, my lord. Now, my lord, this is with respect to, my lord, the impugned judgment on the point of the bank guarantee, my lord. The second argument in substance which was advanced by Mr. Podar was that he has substantially progressed with the work in question and interference in contractual matters should be only in furtherance to public interest and not merely on the asking of the person who himself was otherwise disqualified.
Yes.
In this regard, my lord, Mr. Podar, my lord, had referred to his submissions, my lord, as well as, my lord, the figures and words. Sorry, my lord, just a moment. In his written submissions, my lord, if your lordship would see, my lord, the date which has been given for a moment, my lord, because he has referred to the IA filed before this honorable court, page 10 of his written submission, my lord.
Page 10.
Yes, page 10 of his written submission, my lord.
Yes.
Extent of the work executed by the appellant, my lord, para H. Para 13 at page 85 of compilation 1, in counter affidavit filed by the appellant in writ petition, showing execution of the work to the extent of 75 lakhs. Then he further says that serial number 3, para 4 at page 7 of the IA filed in the present LPA, executed the work to the tune of rupees 8.5 crores on account of earthwork in 21 kilometers out of total length of 24.940 kilometers. Now, my lord, what I want to emphasize here is first, my lord, the pleading itself. My lord, my lord, if your lordship may just take the list of dates, also, my lord, the last page of the list of dates, page 12.
Yes.
Page 12, my lord. As per the appellant itself,
yes,
my lord, he said that he has started the work on 22/10/2019, the last but one date which is mentioned, my lord, in the list of dates at page 12.
Yes.
Execution of the work started by the appellant. It was, my lord, on 22nd October 2019.
Yes.
And, my lord, your lordship should recall, my lord, Mr. Podar had clearly stated, and in fact it is pleaded also, that he started the execution of the work and till such time he filed the counter affidavit before the learned single judge, work of 75 lakhs was completed. And then the work was stopped on 14/1/2020, and during that period, my lord, he says that a further work has been done, that is up to 8.5 crores. So, my lord, these are the two dates, my lord, the dates are only at almost 2 months, my lord, if I put it like that, or maybe 3 months, 2.5 months. Now, my lord, just take the date of his counter affidavit. My lord, these are just the pleadings which he is trying to make before this honorable court. My lord, the counter affidavit on behalf of the respondent, private respondent in the writ petition starts from page 74, my lord. I only want to show to your lordships, my lord, page 98, when he had filed the counter affidavit.
Yes.
The date of the affidavit is, my lord, before the honorable single judge, page 98 is 9/12/2019.
Yes.
So what the appellant is trying to contend that as on 9/12/2019, when he had filed his counter affidavit before the Honorable High Court, he had only completed work of 75 lakhs, which he unambiguously states, and it is stated in his counter. And thereafter, only within a period of 35 days, he has completed the work of further 8.5 crores or a work up to 8.5 crores. This is just, my lord, a bald statement which has been made by him, and this is not the fact which is there and which is evident from these 2-3 dates itself. But, my lord, this is not only the sole consideration. My lord, if your lordships may see my writ petition, my lord, in the same compilation, and this is an admitted fact, my lord, not disputed. At page 32, my lord, of the compilation.
Your compilation?
No, my lord, same Mr. Podar's compilation only. I am showing 2 paragraphs of the writ petition, my lord.
Yes.
Page 32. Para 29. That it is stated that the financial bid of the technically responsive bid of the tender in question has been opened by the respondent authorities, and respondent number 5, Messrs. NG Projects Limited, has been found to be the lowest bidder, having quoted the rate of rupees 94.62 crores. Now, my lord, in context of the above, it is most humbly submitted that the petitioner had quoted its rate at 77.64 crores in respect of the aforesaid work. Now, my lord, there is a difference in rate, my lord. I am not saying that I should be allotted the work, because I am not in a cross appeal before your lordships against the order of the single judge. Now, my lord, this is also a very, very relevant factor when my friend is pleading public interest. My lord, the difference in the rate of work was to the extent of, my lord, 17 crores. And if we take it in the terms of percentage, it is approximately 20%, my lord, between the person to whom the work has been awarded and the person who was there before the honorable court, saying that this was my rate and this is how arbitrariness has been undertaken. But, my lord, the honorable single judge, in its judgment, had gone beyond this also, and had held again on the principles of, my lord, sub saliento fundament, that if the structure falls, my lord, everything falls. And that, my lord, your lordships have already upheld in page 27 of the order passed by this honorable division bench, my lord. May I just read that one paragraph, and there, my lord, I conclude my arguments, my lord. Page 27, my lord. It's para 34, which starts from page 26.
Yes.
But then page 27, my lord, the 3rd paragraph. The learned single judge, while have your lordships, my lord?
Yes, yes.
The learned single judge, while directing the respondent state to issue fresh tender for award of W1 work, has relied upon the legal maxim sub lanto fundamento cadit opus, relying upon the decision in the case of TRF versus Energo. It has arrived at an opinion that once the infrastructure has collapsed, the superstructure is bound to collapse. Learned single judge has quashed the consequential action of the state respondent in award of the tender in favor of the private respondent Agarwal Global Infratech appellant herein as permissible under any other relief prayed for by the writ petitioner in order to do complete justice in exercise of discretionary power under Article 226 of the Constitution of India, relying upon the case of Satyanarayan Singh versus District Engineer, and also in the case of B.C. Chaturvedi, and also in the case of Sangrila Foods and others. Since the award of work in favor of the private respondent appellant herein was found to be flawed on the ground of arbitrariness in matters of qualification in technical bid, the consequential action to award the work in its favor could not have been upheld, since it would amount to allowing the appellant Agarwal Global to enjoy the fruits of a wrong decision. The course adopted by the learned single judge to direct the respondent state to call for a fresh tender for award of the work in such circumstances does not call for any interference. So, my lord, an independent reasoning also by the Honorable Division Bench, my lord, is there, taking note of the reasoning given by the Honorable Single Judge. So, my lord, this argument also that he has completed X amount of work and this your lordships have substantially already repelled. So, my lord, my respectful submission is, my lord, that this appeals are squarely covered by the coordinate bench decision of this honorable court, my lord, and there is no new ground which has been urged by the appellant. Appellant, my lord, private respondent, state is here, my lord.
Right. Yes, Mr. Piyush Chitresh.
Yes, Manoj. I will also refer to the synopsis which was provided by the private respondents, Manoj.
Yes.
Assist this honorable court, Manoj. If Milot may come to Milot's page 104 of the compilation, Milot, which was provided by the private respondents, appellants in this matter, Milot.
104.
Yes, Milot. This is the second call notice, Milot.
Yes.
Milot, in this, Milot, there is a tabular chart, Milot, given in which in serial number 4, Milot, the amount, bid security amount is mentioned, Milot.
Yes.
May I proceed, Milot?
Yes.
Milot, the bid security amount mentioned herein is 105.72 lakhs, Milot.
Yes.
Let's column 4, Milot. Second column deals with the name of the work. Third column's value of the work. Fourth is the bid security amount, Milot. Plus thereafter, clause 3, Milot. Milot, it states that bid must be accompanied by security of the amount specified for the work in the column 4, Milot. That is 105.72 lakhs, Milot. Look, thereafter, on the next page, 105, page number 105, clause 7, Milot. Bid shall be strictly treated to be non-responsive if 1. Bid is not accompanied by an acceptable bid security within a valid period of not less than this, and not secured as indicated in subclause 1 and subclause 2 of the bidding document. Because here, it clearly states that the bid has to be secured with the amount that has been mentioned in column 4, Milot. If Milot will come to Milot clause 16.1 and 16.2, Milot, which is at page 1 and 18 of the compilation, Milot.
Yes.
Clause 16.1 says the bidder shall furnish as part of his bid a bid security in amount shown in column 4 of the table of IFB of this particular bid. Because now Plus, I would like to take my lords to the bank guarantee milords furnished by the respondent here in milords. That is at page 237 milords.
So the argument is being repeated.
Malas?
Argument is being repeated. This has already been placed.
Plus, this has been placed in the these arguments have been placed by my senior friend milords also, and
Amendment is a deviation. Amendment was not permitted.
yes, milords. And milords, the amount also, milords, bid security amount was also different from what it was mentioned in column 4 milords. It was mentioned at 105.72 and here it was 1.6 milords.
Right.
Milords, and thereafter, milords, the issue related to milords affidavit milords, which was furnished by the writ petitioner milords. It was only attested milords, which is at page 253 milords of the compilation 1 milords.
This is additional ground.
Yes, milords, and
There is rejection, but during course of the argument, it was pointed out.
milords.
Undertaking an affidavit.
Undertaking an affidavit where only attested milords are not notarized.
Yes.
Because then I would like to take my lords to clause 23.3 milords of the ITB milords, which is at page 121 of the compilation milords. Yes, milords. Clause 23.3 milords.
Yes.
Technical bid shall be opened if the bid security furnished does not conform to the amount and validity period as specified in the invitation for bid and has not been furnished in the form specified in clause 16, the remaining technical bids will be returned to the bidder. Because this has been replaced in the amendment by, it has been replaced as deemed as rejected milords. So again here there was a deviation, the amount which was mentioned in clause 4 was different to that which was mentioned in the invitation for bidding milords. Thereafter, milords, I would like to place certain judgments before your lordships, milords, to milords.
Judgments you don't place because that has been.
Milords, that we have placed in the first round, milords.
So.
That has been taken care of in the previous.
Yes, milords, that is.
That's all.
That is all, milords.
Yes, my lord. I want to submit something, my lord. So far as the argument made by Mr. Gaudia, my lord. So my humble submission will be in reply, my lord, that whatever point raised by Mr. Podar yesterday, my lord, none of the point has been rebutted by Mr. Gaudia regarding bid security, bid amount, undertaking affidavit. Nothing has been done. So far, as last point which has been raised by the Mr. Gaudia in page 12 of my written submission, my lord, regarding the quantum of work executed on the date of filing of the counter affidavit, as well as on the date of stoppage of the work, my lord. It is well settled principle, law, my lord, in the execution work, my lord. The amount has been given on the basis of the bill submitted on that day, my lord, not regarding the quantity of work executed, my lord. This is my humble submission. On that day, filing of the counter affidavit, on that day, my lord, I have raised bill for 75 lakhs. On the stoppage of the work on 14/1/2020, the bill was raised by me for 8.5 crores. This is my humble submission, my lord. In the
Very well.
yes.
Brother,
Yes.
call you for a while.
Yes. I'm just bringing my phone. Discussion.
लिखिए भाई. अभी भी फोन करके बोलिए, पहुंचा देगा. कुछ बीच में भी टेक्निकल चीज सब लिखाने में. Please send your appearance slips. LPA 85 of 2020 with LPA 233 of 2020.
Three LPAs are there.
These two appeals arise out of the common judgment dated 14th January 2020, passed in WPC 5416 of 2019, and WPC 5894 of 2019. WPC 5416 of 2019, which relates to work pertaining to, within inverted comma, reconstruction of Nagarutari, Dhurki, Korea Road, within bracket MDR-139, bracket close, inverted comma close, which have been referred to as W2 work by the learned single judge. Stop. Stop para. To make the record straight, it is pertinent to mention here that out of the common impugned judgment dated 14 January 2020, three other writ petitions, WPC number 5408 of 2019 and WPC number 5689 of 2019, within bracket, pertaining to, within inverted comma, reconstruction of Meral-Bana-Ambar Korea Road, within bracket MDR 14, inverted comma close, referred to as W1 work by the learned single judge, and WPC number 5894 of 2019 relating to, inverted comma, reconstruction of Dandai Bazar to Panghatwa PWD Road via Lavahi Kala Road, inverted comma close, referred to as W3 work by the learned single judge, were also decided. By the judgment dated 7th October 2021, passed by this court, comprising one of us, within bracket Akhilesh Kumar Singh J, bracket close, latest patent appeal numbers 112 of 2020, LPA number 113 of 2020, LPA number 119 of 2020, and LPA number 234 of 2020, arising out of the same judgment in WPC number 5408 of 2019 and WPC number 5689 of 2019, pertaining to W1 nature of work, were decided. Stop. The appeals were dismissed. The order of the learned single judge was upheld. Stop. The appellate court, the learned division bench, in the above four appeals, upon consideration of the entire material facts and submission of the parties, facts placed from the record and the submission of the parties, arrived at an arrived at the opinion that the tender evaluation committee did not appear to adopt uniform yardsticks in evaluation of the technical bids as respect the bid security under clause 7 read with clause 16.1 and its addendum thereto. In the case of not only the writ petitioner, but also the successful bidder, Messrs. Agrawal Global Infratech Private Limited, and also other successful bidders in technical bid, though they were not, who were not impleaded as party respondents, but the infirmity in their bank guarantee was also brought to the court's notice. One of the successful bidders in technical bid was the appellant herein, Messrs. NG Projects Limited, who had also participated in the tender of W1 nature of work. Stop. The private appellants in the said appeals, Messrs. Agrawal Global Infratech Private Limited, had also taken a plea that since the
जी कौन सी केस में
have been executed pursuant to the award of work in their favor, and that the agreement was not under challenge. The learned single judge had committed a serious error in quashing the consequential action of the state respondent in award of tender in favor of the private respondent, Messrs. Agrawal Global Infratech Private Limited / appellant therein. Stop. However, the learned division bench, in its judgment dated 7th October 2021, accepted the principle applied by the learned single judge, relying upon the legal maxim within inverted comma sub lato fundamento cadit opus unquote, relying upon the decision in the case of TRF Limited versus Energo Energy Engineering Projects Limited 2017 8 SCC 377, to the effect that once the infrastructure has collapsed, the superstructure is bound to collapse. The relief granted under the prayer within inverted comma any other relief in exercise of discretionary powers under Article 226 of the Constitution of India to do complete justice was upheld, relying upon the case of so-and-so 1962 Supplementary 3 SCR 105 semicolon so and so 1995 6 SC 749, and also in the case of so and so 1996 5 SCC 54. Stop. The learned division bench found that when the award of work in favor of the private respondent, Mrs. Agarwal Global Infratech Limited, appellant therein was found to be flawed on grounds of arbitrariness in matters of qualification in technical bid, the consequential action to award the work in its favor could not have been upheld, since it would amount to allowing the appellant to enjoy the fruits of a wrong decision. The learned division bench held that the course adopted by the learned single judge to direct the respondent state to call for a fresh tender for award of the work in such circumstances did not call for any interference. In conclusion, it was held that the employer did not appear to have adopted uniform standards as professed by it to the case of the individual tenderer while evaluating the technical bid. Stop. The selection of one and rejection of another during technical evaluation was neither in consonance with the specific term of the NIT and SBD read with the addendum, nor was on uniform yardstick. Stop. The aforesaid discussion on the outcome of the analogous matters has been consciously referred to for the reason that the present challenge also relates to similar rival issues relating to compliance of the bid security conditions under the SBD and its addendum by the tenderers, of whom the tender of the writ petitioner plus private respondent herein had been rejected, while the tender of the private respondent slash appellant herein had been accepted by the tender evaluation committee. Stop. In the instant case also, as the facts would disclose hereinafter, appellant, a successful tenderer, claims to have executed some portion of the work till it was stopped by the interim order dated 14 January 2020, passed by the learned single judge, and has pleaded equity and principles of public interest to public interest. Stop. The salient facts relating to the present batch of appeals are now hereinafter referred to in brief. Stop. The case of the appellant Messrs. NG Projects Limited, as pleaded by, as canvassed by the learned senior counsel for the appellant, is as under, is being discussed as under. Yeah, is being is as under. the relevant dates, list of dates and events as are not in dispute between the parties are being noticed here in below. बाएं साइड में ये जो है ना, इसका ये कॉपी कर लेना है लिस्ट ऑफ डेट्स का लास्ट तक. लास्ट पेज है इनका रिटर्न नोट. The relevant clauses of the NIT, the standard bidding document, and the addendum thereto, as are necessary for appreciation of the case of the party, are also being quoted here under. Compilation 1 for volume 1. Page 104. इसमें जो पेंसिल से घेर दे रहे हैं, ये इतना घेर रहे हैं उतना कर देना है. ऊपर का क्वेश्चन है पूरा ये टेबल वाला, उसके बाद क्लॉज 3 है, फिर क्लॉज 7 है. Relevant and as pleaded भी जोड़ देना है, which are necessary for appreciating the case of the parties. उसके बाद clause 16, (16.1), 16.2, 16.3, ये पेज 118 पे है. बिड सिक्योरिटी के हेड पे उसका हेडिंग यहाँ भी है ना, उसको दे करके डॉट डॉट करके फिर उसको स्मॉल स्पेस में सिंगल लाइन में कॉपी करना है. ये सब कन्वीनियंस कंपाइलेशन नंबर 1 और 2 से कॉपी करना है, जो भी बता रहा है. 1 मोटा वाला है और पतला वाला है 2. ये है इसके साथ साथ ये मोटा वाला है. उसके बाद क्लॉज 23.3, ये है पेज 121 ऑफ कंपाइलेशन 1 में. इसका एडेंडम जो है वो पेज 207 में है. उसके बाद एडेंडम लिख करके उसको भी कोट कर देना है. चिन्ह है क्लॉज पैरा 207 bid security format है पेज 186 बैंक गारंटी bid security क्लॉज 29.3 है पेज 129 पे 125 पे ये बिड सिक्योरिटी के पहले इसको कोट पेज 125 उसके 29.3 बोले ना
29.3 124 पेज
9.3 के पहले 26.1 ये जरा कोट कर देना 122 पे
26.1
हाईलाइटेड 29.3 है पेज 124 पे reserve the right to accept or reject any variation deviation एक पेज 212 पे है क्लॉज 3.1 212 हाँ इसमें क्लॉज 3.1 का एडेंडम है ये जो कोट करना है इसको एडेंडम ऊपर में लिख देना एडेंडम हेडिंग दे करके और ये दोनों को कोट कर देना और एक क्लॉज 2.6.8 है पेज 201 इसके बाद लिखेंगे सीनियर काउंसिल फॉर द appellant has inter alia made the following submissions that the petitioner had laid challenge to the summary of an order of rejection dated 3rd October 2019 of the Tender Evaluation Committee wherein it was indicated that the tender of the writ petitioner was rejected on the ground within quotes non-responsive due to clause 16.3 of SBT. Stop. However, the detailed decision dated 1st October 2019 of the tender committee pertaining the reasons for rejection of the technical bid of the writ petitioner on two grounds. A, amended bid security was furnished, semicolon. B, bid security was in violation of notification of RBI, were not specifically under challenge. Stop. In absence thereof, the writ petition ought not to have been entertained. Stop. It is the case of the appellant that he, being an eligible bidder, was entitled to show additional reasons which may not have been within the contemplation of the authority as to why the technical bid of the writ petitioner was rejected. Stop. He relies upon so and so 2016 16 SCC 818 para 18. Stop. The writ petitioner did not fulfill the requisite criteria himself and was therefore not entitled to any judicial relief by the writ court. Stop. In support, the decision of Ronak International so and so 1999 1 SSC 492 para 27 has been placed for consideration, placed for assistance. Stop. As to how the writ petitioner was ineligible in many other respects, as regards the bid security, it has been argued as under. That the writ petitioners, that it was only the writ petitioner who submitted the amended bank guarantee. And his technical bid was rejected on this ground only. Total of 13 bidders had participated, in which the writ petitioner had only submitted the amended bank guarantee. The format of the bid security and clause 16 of the NIT providing for bid security have been referred to. Stop. So far as the validity of the bid submitted by the writ petitioner is concerned, it has been stated that the same was also not in consonance with the second call notice dated 20th August 2019, as the validity of the bid security was effective, of the writ petitioner was effective from 8th July 2019. Stop. Resolution of the State of Jharkhand dated 24th January 2002 has been relied upon to show that the bank guarantee should be updated. Stop. As far as the bid amount in the bank guarantee is concerned, it has been argued that the bid security of rupees, instead of the bid security amount of rupees 105.72 lakhs, the bid petitioner had submitted a bank guarantee of 106 lakhs. the figures in digits were different from that of the figure in words, from that of that in words, and as such, it does not conform to clause 3 of the invitation to bidders, and as per clause 7 of the invitation to bidders, it was rightly declared as non-responsive, since the bid was not accompanied by acceptable bid security and not secured as indicated in subclause 16.1 and 16.02 of the bidding document. Relying upon Section 18 of the Negotiable Instruments Act 1881, it has been stated that where there is a variation in the amount stated in words with that of the figures in the negotiable instrument, the amount stated in words shall be the amount undertaken or ordered to be paid. Stop. Petitioners, in the petitioner's bank guarantee, the amount was indicated as rupees 1,06,00,000 lakhs, and in words it was written as 1 crore lakh only. Stop. This was in breach of the bid security format. According to, as per clause 23.3 of instruction to bidders, if the bid security furnished did not conform to the amount and validity period as specified in the invitation for bid and has not been furnished in the form specified in clause 16, the bid shall be deemed as rejected as per the addendum to clause 23.3 quoted above. Stop. Then senior counsel for the appellant submits that besides the variation in the serious discrepancy in the bid security document, that is bank guarantee, the writ petitioner's affidavit and undertaking both were not as per the prescribed format, but were only attested and not duly notarized. The appellant's affidavit in support of its tender document, as also the undertaking in support of the tender document, was duly notarized. Stop. It is submitted that under clause 29.3 of the NIT, the employer has the right to accept of any variation or deviation in the tender document by the bidder. Stop. The deviations which were there in the bid security document, bid security of the writ petitioner were distinct as compared to other bidders. Stop. The bid security submitted by the appellant was not, the bid security, that is the bank guarantee submitted by the writ petitioner, was not rejected on the ground of having added the notwithstanding clause in the format deviation was ignored in the case of the appellant also. Stop. Since the employer had the right to accept any variation or deviation under clause 29.3, the rejection of the technical bid of the writ petitioner on the distinct deviations did not amount to adopting a pick and choose policy vis-a-vis other successful bidders, including the appellant, since the bid security document of the bidder, of the appellant, did not suffer from the same infirmities. Stop. As such, though the bid government guarantee of the appellant did contain a notwithstanding clause which extended, which notwithstanding cause relating to the validity period of bid security क्या लिखे है इसमें?
Though the time guarantee of the agreement did not contain and say not a corresponding clause to the validity period of bid security.
The same infirmity in the case of the writ petitioner had not been made a ground for his rejection, for the rejection of his technical bid. As such, the learned single judge was not right in holding that in matters of acceptance of bid security, the employer had committed, had indulged in accepting the technical bids of the private respondent as well as other bidders, suffered from arbitrariness and unreasonableness, and that the state respondents had adopted pick and choose method, which is not permissible in the eye of law, to satisfy the requirement of Article 14 of the Constitution. Then senior counsel for the appellant, Mr. Poddar, has further submitted that it was well within the capacity of the employer to declare the technical bid of the appellant as substantially responsive, as provided for under clause 26.1. Stop. Reliance is placed on the decision of, he relies upon the case of so and so 2012 6 SCC 564 para 24. Stop. As per the appellant, he he had already started execution of the work and part of the work had already been completed. Stop. Quashing of the entire tender and the work allotted to the appellant not only imposed heavy administrative burden on the administration, but has also led to increased and unbudgeted expenditure. So the appellant had completed earthwork of 21 kilometers out of 24 kilometers. Therefore, retendering of the work was not in the public interest. Reliance is placed on the case of so and so 1994 6 SCC 651 para 94 within bracket 6 and 2014 3 SCC 493 para 19 in support of the submission. Then counsel for the appellant submits that about 75 lakhs worth to the extent of rupees 75 lakhs were executed as per specific statements made in para 13 of their counter affidavit, whereas by the time the work was stopped on 14 January 2020, the appellant had executed work to the tune of rupees 8.5 crore on account of earthwork in 21 kilometers out of total length of 24.940 kilometers. So, the writ petitioner has not preferred any reply thereto. Stop. The work was started by the appellant after fulfillment of the after issuance of letter of acceptance by the state and submission of additional security, performance security, and issue of notice to proceed the work. Moreover, the agreement was executed on 21st October 2019 after the financial bid was opened on 10th October 2019. Stop. As such, the stoppage of the quashing of the entire work allotted to the appellant did not serve public interest. The impugned judgment therefore suffers from serious errors of law and on facts in appreciating the case of the parties. Stop. The impugned judgment deserves to be set aside. Stop. It is further submitted that the decision rendered by this court in the batch of other latest patent appeal, in the batch of others later patent appeals led by LPA number 112 of 2020 relating to W1 nature of work are distinguishable on salient features of the present case, as has been shown to this court, before this court. Learned counsel for the appellant state has adopted the arguments urged by learned senior counsel for the private appellant. Stop. Reliance, he has also referred to the various clauses of the NIT, the standard bidding document, its addendum, and its addendum. Stop. It is submitted that the case of the appellant, the case of the writ petitioner, the tender of the writ petitioner was rejected as not only the name of the addressee was not in conformity with the NIT and the addendum, as the bank guarantee was submitted in the name of executive engineer, Road Construction Department, Road Division, Garhwa, instead of the name of executive, in place of the executive engineer, Road Division, Garhwa. Top. There was the bank guarantee submitted by the writ petitioner was an amended bank guarantee, which was not acceptable as per the terms of the NIT and the SBD. Stop. The amount of bank guarantee submitted by the petitioner, writ petitioner, also differed in the award of work in favor of tenderer who had qualified the terms of the NIT and the standard briefing document, including its addendum. No valid distinctions in the present case, as distinctions uh, with the case of the appellants in the batch of the appeals decided by this court in by judgment dated 7th October 2021. Stop. Then counsel for the writ petitioner submits that the principles on which the judgment of the learned writ court has been upheld by the coordinate bench of this court in the batch of letters patent appeal led by LPA number 1 and 112 of 2020 are equally applicable to the present case. So, he has profusely relied upon the findings recorded by the learned division bench in the judgment dated 7th October 2021. In particular, at paragraphs 24, 23 to 25 and 32 to 35. Stop. He submits that on the principles of the on the principles laid down by the apex court in the case of Ramanna Dayaram Shetty versus so and so 1979 3 SCC 489. The case of the parties has been judged. The employer, that is the executive authority, has been found to have deviated from the standards which it professed as per the terms of the NIT and was under an obligation to scrupulously observe on pain of invalidation. If such decision-making process was in violation of the professed standards. Stop. It is submitted that if the case of the writ petitioner was, if the bid security document of the writ petitioner did not conform to certain specifications of the bid security, the specifications and clauses of the NIT, the addendum, and the SPT and the addendum, the bank guarantee submitted by the appellant, that is the successful bidder, also did not conform to the format prescribed and the terms of the NIT and the SPT. Stop. The appellant had introduced a notwithstanding clause relating to the validity period of bid security, which was not in conformity with the formats prescribed. Stop. The respondent state in its counter affidavit at paragraph 14 categorically stated that the bank guarantee of every tender should be in the prescribed format. Stop. It did not state that the tender evaluation committee, it did not indicate that the tender evaluation committee had made certain deviations as acceptable and certain deviations/variations as impermissible. Stop. Therefore, the learned writ court, while appreciating the case of the parties, found that the employer had not adopted uniform standards in technical evaluation of the bids of the respective bidders. In such a case, the entire tender process had got vitiated and was rightly quashed. Stop. Learned counsel for the appellant has also referred to the decision of the tender evaluation committee dated 1st October 2019, wherein though the tenders of the writ petitioner and other bidders like AK Construction, Messrs. Rajaram Construction, Jalore, were disqualified on certain counts, there was no discussion on the eligibility of the appellant and other successful bidder whose both of whose technical bids were held to be substantially responsive. So, as such, the decision-making process had suffered invariably, warranting interference by the writ court in the powers of judicial review. So, then counsel for the writ petitioner has placed reliance upon several decisions rendered by the apex court, as has also been relied upon in the judgment dated 7th October 2021, rendered in the batch of letters patent appeal led by LPA number 112 of 2020. Stop. He submits that the present case is squarely covered under the said decision of the coordinate bench. Stop. Then counsel for the private respondent or the writ petitioner has also countered the plea of equity raised by the appellant on the ground that it had executed substantial amount of work after the agreement was executed until the work was stopped on 14 January 2020 by interim orders of the writ court. Stop. He submits that the statement made in its counter affidavit filed on 9 December 2019 shows execution of only 75 work to the extent of 75 lakh rupees, whereas by 14th January 2020, the appellant has professed to have executed work to the tune of earthwork to the tune of rupees 8.5 crore, which is simply not believable. Stop. It is further submitted that the writ court, the appellate court, in its judgment dated 7th October 2020, has also taken into account the the legal maxim of sublato fundamento cadit opus as referred to in the case of so-and-so 2017 8 SCC 377 and upheld the decision of the learned single judge in quashing all consequential order action of the state respondent in award of tender in favor of the appellant Messrs. Agarwal, in favor of the said appellant Messrs. Agarwal Global Infratech Limited. Stop. This court had taken note of the decisions at Parat. This court has also taken, the coordinate bench of this, the learned division bench has also taken note of the decisions rendered in the case of Satyanarayan Singh, semicolon, VC Chaturvedi, and Sangrila Foods Private Products Limited, and another Supra, which enable the writ court to do complete justice in exercise of discretionary powers under Article 226 of the Constitution of India, even though such specific relief may not have been paid at the threshold while the writ petition was filed. Stop. Based on these submissions, learned counsel for the writ petitioner has prayed that the appeals deserve to be dismissed as being without merit and covered by the decision rendered by the coordinate bench of this court in the judgment dated, covered by the judgment dated 7th October 2021 in identical circumstances. Para. We have considered the submission of the counsel for the parties at length and taken note of the relevant material pleadings relied upon from the records. Stop. We have also gone through the impugned judgment. We have in the opening paragraph of this judgment, the material clauses of the NIT, the standard bidding document, and its addendum have been profusely quoted as they are squarely in as they are relevant and necessary to consider the questions raised by the appellant and raised by the parties in this appeal. Stop. While the appellant has pleaded that the bid security document, that the tender of the technical bid of the writ petitioner was rejected as non-conforming to clause 16.3 of the standard bidding document and suffered from uncondonable deviations such as in the name of the addressee, road construction, name of the addressee, comma, the bid security amount, as also the fact that an amended bank guarantee was submitted by the petitioner. On the other hand, the deviation in the format of the bank guarantee by the appellant was same as that of the writ petitioner so far as the validity period of the bank guarantee is concerned. But that was not the reason as to why the technical bid of the appellant, of the writ petitioner, was rejected. Stop. Clause 7 of the NIT as quoted above prescribes the clause 7 of the NIT is once again reproduced here under. Stop. It prescribes that the bid shall be strictly treated as non-responsive if it is not accompanied by an acceptable bid security, and small 2, the undertaking regarding validity of bid for a period of 120 days after the deadline date for bid submission specified in clause 20 of the bidding document is not submitted. Stop. The format of the bid security does not, as quoted above, does not permit the tenderer to does not permit to provide a notwithstanding clause relating to the validity period of bid security whereunder the employer had reserved its right as per the bid security as the employer as under the format the employer had reserved its right to get the bank guarantee extended and notice for such extension had been waived. The bank guarantee of the appellant also, however, the bank guarantee submitted by the appellant, however, deviated from deviated from the prescribed format and has incorporated the following clause. The appellant's bank guarantee is at page 250, Mr. Garodia.
The appellant's bank guarantee is at page 244 of the compilation, and format is at page 146, 186.
Format we have quoted. The bank guarantee is at page
250.
Bank guarantee is at page 244.
It starts from 240, but the relevant is at 250, my lord.
250. इसका 250
250 is the relevant.
इसका last part को quote कर दूंगा to page 215. The bank guarantee submitted by the writ petitioner, that is at page 243.
Start 244.
No, the writ
Start from 237, my lord.
237. The relevant notwithstanding is at 243.
Yes, my lord. It is also to page 238 notwithstanding clause. It is also at page in the old one. This is also there is a notwithstanding clause at page 243, my lord.
243 में वो notwithstanding है ना?
Yes, amended में भी है हुजूर. तो at
ये
page
amended ही वाला है 243.
238 में भी है उसमें भी.
हाँ ठीक है 243 का ये notwithstanding से लेके लास्ट तक कर दीजिए. There are other significant deviations in the bank guarantee submitted by the writ petitioner, as has been taken note of here and before, such as in the name of the addressee, where instead of the addressee being shown as the road executive engineer road division Gadwa, the same is addressed to the executive engineer road construction department road division Gadwa. Stop. Besides that, there is difference in the amount in words and in figures in the bank guarantee submitted by the writ petitioners. However, the issue which calls for consideration in the present matter as well is whether the employer conformed to the specifications of the NIT clause 7, the addendum 16.1 and 16.2, the SBD 16. Clause 16.1, 16.2 of the SBD, clause 16 लिखिए, 16, 16.1 to 16.3 of the SBD, and the format of the bank guarantee while evaluating the bid security document of individual bidders, and whether it permitted any specific deviations on a uniform basis vis-a-vis all tenderers, or it chose to accept deviations of individual bidders while refusing to permit deviations or variation in the technical bid of other bidders. Stop. What we gather on a comprehensive comparison of the bid security document submitted by the writ petitioner as also the appellant and the appellant, we gather that the bid security document submitted by both the tenderers failed to adhere to the specifications professed by the employer. Stop. While the appellant in the final paragraph of the bid security document made the bank guarantee extendable at the bank's sole discretion. Contrary to the requirement of the format and the bid document, whereunder the employer had the right reserved to get the bank guarantee extended and notice for such extension to the bank had been waived, the writ petitioner had also deviated on this count by introducing a notwithstanding clause which was not part of the format. Stop. As has been held in the case of Ramana Dayaram Sethi Supra, an executive authority must be rigorously held to the standards by which it professes its action to be judged, and it must scrupulously observe those standards on pain of invalidation of an act in violation of them. The action, the decision-making process of the employer in the instant case also does not conform to uniform standards, uniform yardsticks in evaluation of the tender documents, especially the bid security tender, in evaluating the tender of respective bidders, specifically the bid security document. Stop. As such, the action of the respondent government cannot be said to be free from arbitrariness, which is the very essence of the rule of law. Stop. This court on on those counts finds that the case of the decision making process relating to award of work in W2 nature of work, award of W2 nature of work also suffers from the same vice as that in the W1 nature of work. Stop. The principles of law as enunciated by the apex court and profusely relied upon by this court in the judgment dated 7th October 2020 do squarely apply to the facts, therefore do squarely apply to the present case as well, to the facts of the present case as well. Stop. If the learned single judge if the opinion of the learned single judge on those counts do not suffer from any perversity, there is no reason for the appellate court to take a different view of the matter and substitute its opinion. Stop. We are also in agreement with the principles upon which the learned single judge quashed the entire consequential action of the respondent state in award of the tender in favor of the appellant, Messrs. So and so, NG Products Limited. So, the principles relied upon by the learned single judge on those counts, relying upon the legal maxim within quote sublato fundamento cadit opus unquote, as also relied in the case of so and so 2017 8 SCC 377, have been accepted by this court, its judgment dated 7th October 2020. Stop. We are also in agreement with the view of the learned court that it was permissible for the learned single judge, in order to do complete justice in exercise of discretionary powers under Article 226 of the Constitution of India, to grant, to cause the consequential action of the state respondent in award of work to the appellant in such circumstances, since once the infrastructure has collapsed, the superstructure is bound to collapse. Stop. Stop me. Otherwise, it would amount to allowing the appellant to enjoy, the appellant Messrs. NG Products so and so, to enjoy the fruits of a wrong decision. We are not convinced with the with the plea of equity raised by the appellant NG Products Limited on this count. Stop. It has been shown on the part of the writ petitioner that while the writ petitioner had quoted, in this context, the writ petitioner had shown from the pleadings on record that while it had quoted a financial bid of 77.64 crores, rupees 77.64 0.64 crores, the appellant had quoted a financial bid, had offered a financial bid of rupees 94.62 crores for completion of the W2 venture of work. We, however, do not wish to make any comment financial upon the financial bids quoted by the rival parties, as the issue at hand is confined to the rejection of the technical bid of the writ petitioner while accepting that of the appellant on the part of the employer state. Stop. Having analyzed the reasonings rendered by the learned single judge in the conspicuous facts of the case, we are of the view that the decision of the tender evaluation committee in accepting the tender technical bid of the successful tenderer Messrs. NG Products Limited Limited, while rejecting the technical bid of the petitioner, did not conform to uniform standards as professed by it. Stop. The selection of one and rejection of another was neither in consonance with the specific terms of the NIT and the SBD read with the addendum, nor was on uniform yardstick. Stop. As a result of the aforesaid discussions and for the reasons recorded here and above, we do not find any merit in these appeals warranting interference. Accordingly, the appeals are dismissed.
May I submit, my lord? May I submit, my lord? One more point was argued by the appellant, my lord, that is regarding bid capacity, my lord.
That you had argued.
Yes.
Was it a point taken in the writ petition?
Yes, my lord. It has been mentioned in my written submission at page 9, my lord.
वहाँ उनका सबमिशन जहाँ कर रहे थे वहाँ पर लिख लीजिए.
Page 9 में, para G में.
And senior counsel for the appellant NG Products Limited has Mr. Poddar has also tried to show that from the counter affidavit of the appellant that the writ petitioner was disqualified on account of bid capacity as per the formula prescribed by the employer, which is quoted in para 18 of the counter affidavit of the state. Hey, now.
And the details has been mentioned page 10, my lord. Para 16, my lord.
As per clause 2.6.8 of the SBD, the writ petitioner was disqualified on account of bid capacity, which ought to have been more than the estimated cost of the work, which is to be assessed as per the formula mentioned in the said clause. Pending IAs pending IAs are closed. That's all, brother. Anything else?
It's okay, sir. Everything.
Very well. Let's go to the videos.
Much obliged, my lord.
Okay. There is one hearing matter which somebody had mentioned. Parties are ready. We'll resume after lunch.
Yes.
Serial 25, Lordships.
Yes, yes.
Yes, Lordship. I am appearing for the petitioner.
Okay. So we'll resume after 1 hour, about 3.
As well, Lordships. Grateful.
एक केस बच गया सुबह हम बोलिए सर दूसरे का